Good afternoon, everyone, and welcome to our Accommodation Advice webinar for all Macquarie University students. We're going to be starting very soon, and whilst I can't see everyone's faces, I can see though that we've got a number of participants joining. We're just going to give everyone a few more moments to join, as we are expecting around about 100 students to join in this session today. And of course, for those who have registered but unable to attend, we'll be providing the recording from today's session as well. So just a few more seconds. Okay, so my name's Kylie Ebert. I'm Director of Student Life here at Macquarie University, and I'm pleased to be able to host today's webinar about accommodation advice. Obviously, we know this continues to be a very challenging time for all students as we navigate the challenges that the global pandemic has caused. One thing that we are very aware of, and we're listening to our students and trying to understand their needs, we're very aware that accommodation is proving to be a significant issue for our students, and that it is important to have access to up-to-date and expert advice in this area. It can be tricky to navigate, and we're very keen to make sure that students are well informed about their rights and their responsibilities, but mainly with a view to helping solve and provide some advice to keep you on track with your studies. So before I introduce today's panelists, and we've got some experts here for our session, just a couple of housekeeping matters. We're going to be addressing the questions that have already been asked, and thank you to everybody who submitted those questions in advance. If you do have additional questions during this session, please use the Q&A function, which you should see on the bottom right of your screen. Behind the scenes, we've got a whole host of people, staff from Student Wellbeing, Macquarie International, lots of different people here helping us to answer those questions as we go. We're going to be able to cover a lot of ground today, but I need to be clear that it is general advice we're providing. Everyone does have very specific circumstances, and we won't be able to provide personalised advice today, but we're going to give you some very specific referral points for follow-up so that we can assist you at a later date. You may notice that when you ask a question, it's dismissed or flagged as being answered live. This means your question either has been answered or will be answered during the session. And a really friendly reminder to everybody that we are using a university system. We're very mindful of respectful behaviours, and student conduct and IT policies do apply. So let's get down to business for today's accommodation advice webinar. First of all, I'd like to introduce Sean Stimson. Sean is the Solicitor and Head of the International Student Service at Redfern Legal Centre. He's the brains behind the My Legal Mate app, which I'm hoping all of you have downloaded and already been accessing for today's session. We had the pleasure of working with Sean last year when we launched that at Macquarie University, and I'm really pleased to welcome him back to continue to help our students. So thanks very much, Sean, and perhaps today you can start off by just introducing us yourself, giving us a little bit of your background, and certainly telling us a bit about the work you do for international students and in fact all students at the Redfern Legal Centre.
Thank you, Kylie. Yeah, my name is Sean Stimson, as Kylie kindly outlined. I've been the solicitor at the Redfern Legal Centre for almost 6 years now. The practice itself was set up in 2011 as a dedicated practice to provide assistance to international students studying in New South Wales. I think when the practice started, we had about 110,000 students enrolled in New South Wales. Now I think we're at something like 266 1,000 international students currently enrolled to study. I think where we find ourselves today, it's slightly different. Numbers exactly the same, 266. Around about 100,000 of those students are currently offshore and 166 are onshore. Now, as a service provider, we still provide legal advice to all of those students, regardless of their location within the globe. The advice that we give can be across any legal issue that a student may experience whilst they're studying in New South Wales. The concerns that we have always had, and one of the reasons why we have the relationship that we do have with Macquarie University, is indeed around how we engage with all of those students, and that's why MLM was introduced, and Macquarie were the first university in New South Wales to pick it up, and we congratulate them for that initiative, for providing that to you. The concerns, I suppose, today that we're looking at is the biggest issue that we're currently seeing through the practice, which is around tenancy issues, and that's what we'll be covering through today. Thank you, Kylie.
Absolutely. We will focus in on accommodation issues specifically, but I know that you've raised a couple of key points there already, in that this is affecting international students both in Australia and offshore, and so it's great to hear that you're able to support students regardless of where they're located at the moment. But we're in also talking about the app. That's probably one of the best ways to access initial information, isn't it? And it's got the added benefit of being in 6 different languages, or 7 including English, 6 other languages for students, because we know at this time when it's, you know, there's challenges and legal things, it's reassuring to have things in your own language, isn't it?
Yeah, look, absolutely. When we first thought of the product itself being My Legal Mate, we actually surveyed a significant proportion of students as to how they wanted receiving information. And the one thing that came through was language was a key issue. And initially we were surprised by that, because the students that we deal with on a daily basis have incredibly strong language skills. But I suppose where it then became apparent that they wanted it in a community language was they were talking on subject matters that were outside their normal sphere of knowledge, I suppose. So terminology was slightly different. So therefore, community language became a key requirement. And I think also when you're looking at technology, you're able to access it at any point in time. You're not reliant on jumping into a legal service, whether or not it be the service that we provide as Redfern Legal Centre, or indeed the services that Macquarie University provide. It's something that they can actually look through the problems. It provides them pathways. They can almost self-manage if they want to. It's been designed so that they can self-manage a problem. Or if they still need to engage, they can engage with, again, Macquarie University or organisations such as ourselves. So it was designed as a platform which informs students in their own language as to the issues that they have, and with the ability to manage their particular problem.
Yeah, you're right. And I mean, these are the sorts of things that I know if I've got something on my mind, it's always late at night that these things come up. So really great that they can access it any time and then follow up with our services as needed. Now, I know that you've been working really hard on some updates of the content to deal with some specific issues related to COVID. So can you tell us a little bit about those updates and exactly what's happening? The government's made some changes to legislation to help renters and landlords during this difficult time, but perhaps you can give us a bit of an overview of where that's at and how you've updated that in the My Legal Mate app as well.
Yeah, of course. And I think it's incredibly important as well, because the landscape, I suppose, is moving incredibly quickly from a legislation point of view. So being able to provide the most current and up-to-date information is absolutely imperative. What we have done is we looked at the moratorium, as you were probably aware, and students are also aware, is that government introduced the moratorium that came into effect on the 15th of April, which prohibited landlords from evicting their tenants. It is that information, I suppose, that formed the basis of the updates, and it speaks around the duration of the moratorium, what the moratorium actually looks like, what a landlord can do, and what the tenants themselves can do. Happy to go into more detail. I'm sure we will throughout this webinar. But in essence, it provided.
I am reading this text out loud.
In essence, it provided some security to students for a 60-day period from the 14th of April, which meant that they couldn't be evicted from their tenancies during that period of time. The expiration date on that obviously placed it around 14 June. And it's changed a little bit, I suppose, around the ability for a landlord now to look at removing a tenant from that accommodation. There are some other conditions that are associated with that, and that is the fact that the landlord and the tenant must have entered into negotiations, fair negotiations, and if they fail to come to an agreement, then the tenant could be evicted, and I stress here could be evicted if they are 14 days behind in their rent, and or that the landlord had made an application to the tribunal, in this case NCAT, New South Wales Civil Administrative Tribunal. So I think that's the guts, I suppose, of the amendments that were made to MLM. Were updating students around their rights and what they should be doing in order to get reduced rents and obviously remain in that tenancy.
Absolutely. So that's so as I can paraphrase that for everyone, and you can correct me if you know, this is new territory for me. I am a renter, so it is very important information for me as well. That moratorium on 60 days of evictions from a landlord for falling behind ended about the middle of June, but there's been processes and things in place where you can have those discussions with your landlord. And if they're in train, you may be evicted if you're more than 14 days behind, but there's lots of things we can explore, and we're going to go on to ask some of those specific questions now. That's where we seem to be at with it. So we do have a lot of specific questions from students, and I think it is best that we start out in that area of rent reduction, because a very obvious question that some of our students have asked is, how do they go about asking a rent reduction with their landlord? What's your advice on that one?
Yeah, it's a great question, and it's a question that we're getting a lot coming through the practice, and I'm sure you are as well. In the first instance, depending on who you're renting from, and I suppose you would need to look at the type of accommodation that you're renting. In this instance, we're talking about accommodation that is formed underneath the Residential Tenancy Act. And in that situation, you would either be renting from a landlord or you'll be renting from a real estate agent. If you're renting from either of those, either the landlord or the real estate agent, you would engage with them in writing. And it's really important that everything that we do is placed in writing. So if you have a contact email, send it to that contact email, and you would state the fact that you are no longer in a current situation to be able to afford to pay the rent, and you wish to negotiate a rent reduction. If the landlord doesn't respond, which we have seen a little bit of, you're entitled to go to an external organization, and that is Fair Trading. And Fair Trading will actually act as a mediator in this, and they will actually form part of the discussions as that mediator to discuss the rent reduction between yourself as the tenant and the landlord or the real estate agent. And it's at that point you would need to be able to come to some form of agreement. It's important to stress, in order to seek a rent reduction, the household has to have been affected by COVID-19. And when I say household, I mean if there are 3 people that are residing in that property, collectively, the income to that property must have reduced by at least 25%. Now, if 2 are working and 1 has lost their job completely, then the income to that building is actually 33%. So, or that dwelling is 33%. So you'd be able to qualify for that rent reduction application. The landlord or real estate agent must, in good faith, negotiate a payment that is affordable to the tenant itself. If no agreement can be reached, then it becomes slightly more problematic in terms of what can happen after 14 June. So that is the eviction that we spoke on earlier.
Okay, so basically, and again, I'll just keep checking in that I understand exactly what we've said here, that the first step for people is to put it in writing. And I know that from some of the questions our students have asked, they've definitely done that. They've approached their landlord in writing and they've indicated that they would like to negotiate a reduction in rent. As you said, it's looking at the household and showing that they have had an impact of COVID, and that is that they have lost employment. Again, we know for so many of our students, they've either lost their casual jobs or they've certainly had their hours reduced. But it's to show that at least 25% of the income of the household has been lost because of the impact of COVID. And that the idea is that there'd be an affordable rate set with the landlord. And you've said, and hopefully that's, you've got a really reasonable landlord who comes back and says, sure, and you agree in writing and move forward with that. But we've covered the next question someone had asked us, is what happens if you've asked in writing and haven't had a response? And that's when you've suggested that fair trading is the next point of escalation, and they can help by being a mediator. And we'll be able to follow up for students with those contact details for fair trading, should that be required for people's situation. Now, one of the other questions we've had is somebody did receive a rental reduction for 3 months, but their situation hasn't changed. So what should they do? Do they go back to the landlord and are they entitled to ask for an extension on that? Or is at the end of 3 months, the landlord would go back to charging the full rent? Oh, looks like we might have an internet. Oh, yep, we've got you back again.
Most situations.
Yeah, we might need video. It's a little unfortunate if we can't, but it might help with the quality of the connection. No, that's not a great connection there at the moment. So we'll see how we go with this, but I'm just conscious, and I'll remind everyone.
Can you hear me?
Yeah, we can hear you there now.
That's wonderful.
Great. So yeah, that question was, can you ask for another rent reduction at the end of a 3-month period?
Yeah, look, you certainly can. Certainly what we're seeing is that in the first instance, landlords have issued the reduction for a period of time. And the period of time usually is covering to 14 June. Thereafter, yes, you would need to, if your original agreement does not cover any further than the 14 June or whatever date is specified, then you would need to be able to go back to your landlord or real estate agent to renegotiate the continued reduction in rent. I think an important thing to note here also is that we have seen some landlords making suggestions that students access their superannuation fund to be able to cover the rent reductions. It is unlawful for the real estate agent or landlord to make that recommendation, because it actually falls into the realm of financial advice. So if that's ever happened, you would need to point out to the landlord that they are not entitled to provide you that information. So you certainly would attempt to negotiate a longer period of time. Again, everything should be placed in writing. Now, if the landlord or real estate agent does not agree to an extension in time, they are able to, and this is as we entered this conversation, they are able to look at evicting you from the property, but you would need to be behind by the 14 days. So that is in arrears by 14 days of the original cost of your tenancy, not the reduction amount. If you are not able to maintain the full payment, pay whatever you can afford to pay and have the matter determined by the tribunal themselves, because the landlord still must, as part of the moratorium, have entered into negotiations with the tenant to come to an agreement. The tribunal will make the determination as to whether or not the landlord has entered into reasonable, fair and reasonable negotiations. And if they have not, then that could change the outcome in regard to the eviction.
Okay, and so obviously if we had any students needing to progress to a tribunal situation, that's where your service would definitely be able to support them through the process. That's correct, isn't it?
That is absolutely correct. I mean, in the first instance, what we would do is we would assess what the landlord has or hasn't done. We'd advise that accordingly, and if need be, then we would certainly assist them through the NCAT or tribunal application. And when I refer to NCAT and tribunal, it's the same organisation. It's not two separate organisations.
I noticed popping up in our chat a question. We've talked a lot about people who are living in private accommodation with either a landlord or a real estate agent that they're dealing with. And a question has popped up about a person who's living in student accommodation provided or associated with Macquarie University. We have a range of providers. And I guess I just wanted to reiterate to everybody on today's session that all of our providers, so that's Igloo, Robert Menzies College, Dunmore Lang College, Morling College, Macquarie University Village, and also the university's accommodation. All of our providers are very open to discussions with students, individual discussions to negotiate rent reductions and payment plans as needed. We spend, through the accommodation team and myself, we spend a lot of time having these discussions with those providers, and so certainly students should not feel scared or worried about going and having that conversation. They're very open, they're very receptive, and they've put arrangements in place for many of our students. So that's been a positive thing within the university environment. Just moving on, Sean, we've had a question and it's something that came through earlier, but someone on the chat I noticed had raised that they've had to exit their accommodation, but their landlord has kept their bond, and there might have been minor wear and tear, or in some instances they've just kept the bond. What can they do about that to try and get that bond back? Obviously, we're finding for students that's very important that they have their bond to be able to move on to more suitable accommodation.
Yeah, that's a great question, and again something that we do see a lot of. A bond is certainly held by the landlord to cover any damage to a property. If you have not received your bond back, you can make an application to what used to be referred to as the Rental Bond Board, but is now Fair Trading, and you will, against the address that you have and or a receipt number. So your landlord at the beginning of your tenancy should pay your bond to Fair Trading. If they fail to do so, there is actually a penalty against them of $2,200. So it does give tenants some leverage as they move forward. But if we work on the assumption that it has been paid to Fair Trading, you can make an application yourself to have that bond returned to you. Once you make that application to Fair Trading will send a request that the bond has been sought to be released by the tenant, and the landlord or agent would have 10 days to respond to that request. If they do not respond within 10 days, then that bond will be paid out to the applicant, the tenant. If they do respond and say, no, not to pay the bond out because of X reason, then it would be a matter that you would try to negotiate with the landlord. If you don't come to an agreement, then you would need to take it to the tribunal again for them to determine whether or not the landlord should pay you the bond back. And they will look at the claims that the landlord is making against retaining the amount that they're looking to retain on the bond.
Okay, so again, a student can apply to fair trading for the return of the bond, and we'll pop in our follow-up resources and information for students, a direct link to that application process so that we can assist students there. I noticed someone's popped up, they've got a landlord who they are seeking broken bulbs and things to be replaced when that was in that condition when they entered the property. I guess that's important advice, Sean, when people are taking a lease. They should really check the condition of the property and things like that in relation to the bond, and that's probably good advice at any time rather than certainly not restricted to COVID times.
Yeah, absolutely. As you enter a property, you should be given a condition report of the property that you're moving into. Check that condition report to the actual condition of the property that you're moving into. And if you don't agree, state that you don't agree, and that is the document that would go back to the landlord or the real estate agent. So if in the future, when you then are leaving the premises, they infer that there is damage that was already there, you can indicate on that original inspection report that the damage was certainly existing. It is always good advice, I think, to take photographic evidence as well as to a property, especially when you leave. If you've had the property cleaned or you've cleaned it yourself and it's left in a good condition, show that, take photos of that. It's good to be able to substantiate your position in writing or photographically.
Absolutely, good advice there. Now, the next group of questions are probably the most important ones for our students, that they've reached a situation where they need to get out of their rental agreement, that it's either not sustainable for them anymore to live in this place or not suitable for their accommodation needs anymore. So we've got, the obvious question, how does a student go about exiting their lease early before the end of that rental agreement period? How do they do that, and what do they really need to work through to do that within the parameters of the legislation?
There's a few parts to this, so if you want
Simple
to interrupt...
question, but tricky answer, I'm guessing here, Sean.
Yeah, tricky answer, absolutely. So, I mean, if you want to interrupt and then run through that section, I'm happy to do so.
I'll take some notes.
Okay, that's great. The first instance, I suppose, is the obvious one, by consent. So if you want to leave, have a discussion with your landlord or real estate agent and give the reasons why you want to leave. If they agree, then you can agree on those particular terms. Anything that is decided by consent, though, must, I suppose, be looked at in regards to what the law actually says, because you may be better off to apply the law to your situation. Now, leaving a property, it doesn't matter if you are in the property or if you are overseas and you're not able to have taken up that tenancy. The same advice remains exactly the same. I suppose a student would find themselves either in a fixed term lease or a periodic lease. If you are in a periodic lease, which means that you have completed, usually it would be a 6-month leasing contract, could be longer than that. If you've completed 6 months of that lease, you then go on to a month-by-month lease, which is called a periodic lease. If that's what you were on, you can provide written notice to the landlord real estate agents of 21 days that it is your intention to leave the property. Again, everything in writing. Put down to the landlord that you are on periodic lease. You give 21 days notice. Whatever 21 days notice is in future, you provide that end date. You vacate the property on that end date, providing the landlord with the key and in a condition that you found the property.
Okay.
So that's
On that,
number
we've
one.
just sorry to interrupt you there. We've just had a question come in on the chat that if a person does leave, give their notice and exit the property with agreement, and they've left the property in good condition, they should be entitled to their bond back. Is that correct?
That is absolutely correct. There is what's referred to as fair wear and tear. Sometimes landlords will try to claim for items that perhaps shouldn't be claimed. If there is damage to the property that was not there, that is that the tenant caused that damage, then the landlord is entitled to recover those repair costs associated with it. If you do not agree with those repair costs, then you can try to negotiate with the landlord. And if those negotiations are not successful, then you can have the matter heard again with NCAT, the tribunal.
Okay, so that's by consent or if you have a periodic lease. And again, you've stressed in both those instances that it's best to do, you should always be doing this in writing so that it's clear. What would happen if a student doesn't have a lease agreement in writing, that it's been a very informal situation to start with, Sean?
That is a great question.
It is. I threw that one in without any notice for you. Just to keep, your stuff here, Sean.
It's a worthwhile question, and it is unfortunately something that we see. And again, I'll come back to really quickly is My Legal Mate is a really good resource because it tells you what you should be looking at the beginning of every situation, regardless if it's your tenancy, if it's employment, whatever it is, it gives you a understanding of what you should be doing. Now, if you have found yourself in a property where you have no written agreement, then it could be that you are outside of the relevant legislation, that is the Residential Tenancy Act, that provides the protection for the individual, that is the student. What we have found is that quite often, from an intake point of view, when a client comes to us, they will say, I have no written contract. However, if you have some information, and when I say some information, it could be that there is a text message to and from the landlord which says, yes, I'll be moving into the house X on this day, that can form part of an agreement. And what the tribunal will try to do, and again, you should seek the assistance either of the wonderful staff at Macquarie University or ourselves, they will try to make that fit to form a residential tenancy agreement. Although not formed on the correct documentation, they will try to make it be formed through those conversations that have been had.
Okay, so that's really helpful, that if there's any communication and evidence of those texts, emails or exchanges that you have had, that it's really important students have a copy of those and they can help work through that matter. One of the questions we've had is, and it relates to, you've explained that if we are getting out of it a lease agreement by consent or by giving 21 days notice for a month-to-month arrangement, does that have to be for COVID related and financial issues, or could you do that under any circumstances?
So that's under any circumstances. There is one new amendment that is specific to COVID, and I'll probably touch on that one last if I may.
Sure, we'll hold that one because I do have another question for you then. But But if it's by consent or periodic, it can be any reason, is what you're saying to us there, which is good to know.
That is correct.
What we're finding for some students is that they are in rental arrears. That is, they have fallen behind on their rent. And in that situation, it becomes even more imperative that they find more suitable accommodation and get advice so that they're not accumulating more and more debt. How do they go about getting out of their lease if they are in debt to their landlord?
There's nothing that's stopping the person still from exiting their lease agreement. What you would likely find, though, is that the bond that was paid would not be sufficient enough to pay the rent arrears. And if we work on that assumption that the bond does not cover it, then the landlord is certainly entitled to recover for those arrears. The best outcome in that situation would be to enter into an agreement, an affordable agreement with the landlord. So if you have an amount that is outstanding after the bond has been provided to the landlord, and in this case it likely would, because NCAT would order that there was an amount that was outstanding, then that agreement would need to be something that was affordable for that person to pay. If they are not in a position to pay the outstanding amount, then it could be that the landlord would be wanting to pursue action to recover that amount of money. In the first instance, they could try through NCAT, or they could pursue an action through the small claims court if the amount is under $40,000, which one would, over 40,000, otherwise it'd be NCAT under $100,000, which one hopes it would likely be under that amount of money. They have 6 years to recover that debt. And I think importantly, Kylie, stepping back to the recovery of monies in the previous example that we were talking about, where the client didn't have a written agreement, if they had paid a bond to the landlord and they weren't covered underneath the Residential Tenancy Act, then they would also need to pursue an action through the courts to recover that bond. Now, there are two options that are available to the student or the tenant in that situation. One would be through NCAT consumer division, because the landlord or the real estate agent are in the business of renting rooms, and they would then make an application to recover the bond component, because it's then a debt-based matter.
Okay, so I'm conscious of time. We might just cover a few more questions quickly before moving on to cover some of the university's student supports available. But one thing we've had a question from a student who was obviously in a share house arrangement, and their roommate has actually had to return home due to COVID, unable to pay the rent, and we have one student there now needing to cover the rent on their own. What would be your advice to them to talk to their landlord, to approach them in writing, or what would you suggest for that person?
Yeah, look, absolutely. The legislation or the law says that a person that is a co-tenant, or if you are a co-tenant and the other person fails to pay their rent or leaves in this case, then the remaining tenant is liable for that portion of rent. So that is the unfortunate situation. So it could be that the student looks to place another co-tenant in the place of the tenant that has left. It is always advisable to get the permission of the landlord. However, a landlord cannot reasonably refuse you placing another tenant into that particular space that has been left by the tenant that has gone. But in the first instance, I would say attempt to negotiate a reduction in rent that reflects the other party leaving, and then introduce another tenant that will fill that void. Importantly, the tenant that is left in the property is able to pursue recovery of those rents that they have paid against the person that has vacated. So that becomes a debt again, and that would be something that they'd be able to pursue through the local court. Again, that is something that we would be able to help a student do to recover that particular debt.
Okay. And we've got someone who has not got that written agreement. They have paid a bond, but they did not get a receipt. And after leaving that property, they've not had their bond returned to them. Without that agreement, is that something they can take to the tenancy or fair trading?
It would depend on again on the information. If they have enough information around it and the tribunal is able to determine that that is actually a tenancy agreement, then they will try to make it fit into that particular characteristic. So it may well be. It would certainly turn on the information that that individual actually has at hand. If they have no information, that is, that they have no knowledge of who the landlord is, there is nothing in writing, then it would be incredibly difficult for the tribunal to be able to establish that there was some form of written agreement in place. So it would be problematic.
Okay, so again, it's really important that students are keeping records of these paperwork, any email exchanges or things that they've had, text messages, in lieu of a written agreement, still to keep that documentation. We've still got a very similar question that a person has been asking their landlord for a written contract. They've had no response. They were asked to transfer bond money into a bank account and to pay the rent in cash. So obviously this is something that would not form those particular written agreements and things as per the Rental Tenancy Act. But if they were able to gather that information and come in and get some advice from you, you'd be able to assist them. They're trying to get their bond back again rather than being charged too much for the wear and tear on the property as they've exited.
Yeah, absolutely. I'd certainly recommend that the client engage with us, and we'd be able to piece together the information that they have and advise them more in depth on that.
Okay, so that probably covers most of the key questions we've had here, Sean, but I do just want to get you to reiterate a few key points for us, because we do have, students that even after having a rent reduction can still not afford to stay in their property, and the best way to exit that is by consent or with a written notice if the agreement has ended and they're on a month-to-month relationship. So perhaps you can just reiterate those final points before we get some advice from our student wellbeing area.
Yeah, look, I'm going to add to that as well, if I may, Kylie, because
Absolutely.
I think there's probably two other things or three things that I think are really important as well. You're quite right. We were talking about periodic. If you are not in a periodic, that is that you're in a fixed term lease, and your lease was for, say, 12 months, and you wish to break that lease as it currently stands, and we're talking in any situation, not specific to COVID, if you were in the first half of that fixed term lease, so you haven't completed 6 months of the 12-month lease, and you wish to break it, it would cost you 6 weeks of your current rent. If you were in the second half, that is that you had completed more than 6 months of the 12 months, it would cost you 4 weeks of your weekly rent.
Okay.
Now, I'm going to carry on if I may.
Yeah, no, absolutely. I'm saying okay because that's a really important point, and we want to be able to emphasise that to people to be able to, if they do need to exit, that's the payment that they'd be needing to factor in.
Indeed, and there's something around COVID that is important to a fixed term as well, and I'll visit that in 1 second.
Sure.
The other important change to legislation occurred on the 23rd of March of this year, which if your tenancy was taken up after the 23rd of March, then those two figures that I just made reference to, being the 6 and 4, depending on where you were within your rental term vary. So from the 23rd of March 2020, if you 4 weeks rent if less than 25% of the fixed term has expired. Yeah, I might provide you a link with this.
That would be great. I'm working out now. So if you've signed after the 23rd of March and you have been there less than a quarter of your lease, you can pay 4 weeks to get out.
Yep. And it's 25%.
Yep.
3 weeks rent if 25% or more, but less than 50% of the fixed term has expired.
Okay.
Yep.
So
2 weeks rent.
50% expired is in the 3 week category.
Correct.
Yep.
2 weeks rent if 50% or more, but less than 75% has expired.
Oh, okay. I can see where we're going with this.
Yeah, absolutely. It's going down each time.
Yes,
So the longer you've been in it, the less it costs you.
Okay, that's good to know.
And then 1 week's rent if 75% or more of the fixed term has expired. And that's for all tenancies that have occurred after the 23rd of March.
Okay.
Now, can I ask a quick question? If I were to drop that, I've actually got it written down in front of me as well. If I were to drop that into the Q&A, would that show up for the students, or would you rather I sent it to you?
If you send that through to Natalie on our Q&A, she'll make sure that's posted out to everybody. Okay. And that's exactly the sort of valuable information we'll follow up with in these resources, because look, I can tell you now, if I was reading that on a website for the first time, Sean, I'd have trouble negotiating it and understanding it myself, but I can get that now that you've explained it, and I just want to go back and double check it on those words you've said. So that would be very useful for me and for the students as well. Is there any final points there, Sean, that you want to reiterate to students? Obviously, get things in writing, have those discussions and have evidence of it with any landlords or tenancy, landlords or rental agents. Students should be looking obviously at My Legal Mate and asking and making an appointment to see you at and the team at Redfern Legal Centre if there's a complexity about their issue that might need some more advice.
Now, I'm going to close on tenancy, if I may, which is really important around COVID. If your landlord or real estate agent won't negotiate or are slow to negotiate in a rent reduction, and it is something that is an affordable outcome for the tenant, then the tenant is able to make an application to the tribunal to terminate their tenancy, which under the COVID, as is just described, that your landlord has failed to negotiate or has not negotiated to an affordable outcome, then the tenancy can only be capped at a maximum of 2 weeks penalty to the tenant itself. So at their discretion, the tribunal can award up to 2 weeks to the landlord. In most situations, it's considerably less than that. So if you look at all of the scenarios that we ran through with the student or tenant trying to vacate their tenancy, it is far less to go that particular route, with the exception of if you had your tenancy from the 23rd of March and you're halfway through it, then it would be the same.
Sure.
The disadvantage is that it's likely going to take you about 7 days to have your matter heard at the tribunal. However, if you were to notify your landlord or real estate agent that it's your intention to make that application, you may be able to come to an agreement, but that agreement should be no worse than 2 weeks that you pay.
Okay, so what we might do is we'll get all this information from you, Sean, and we'll pop it in a table for students so that they can refer to it and send it out to people next week. As you say, there's a number of different options here, and depending on whether or not there's a written agreement, there's not a written agreement, depending on the extent to which the household has been affected, how far they are through. There are different options along the way, but we can get that out to a table and a follow-up for our students. So yeah, I just want to say thank you so much for that, Sean. I've learnt an enormous amount, and yeah, I think it's been absolutely fabulous for our students. So I appreciate your time today. I'm now going to ask Dr. Ben Wilkes, our Associate Director of Student Wellbeing. Ben's at the coalface of the implementation of our Student Success Support Package. So Ben, I really need an update from you about what's happening for session 2 with the Student Success Support Package.
Good afternoon, Kylie, and my thanks to Sean as well for providing the helpful information about accommodation and tenancies. In regards to session 2, the university has really acknowledged the continuing need of students in the population and the continuing need to have access to funds for their daily living. And the number one way the university could support that during session 2 was to allow students to delay their payment of their tuition fees to 2021. So this is without interest, without any penalty payments for non-payment in 2020, just to delay their fee payments to 2021. So to date, we've had up to just over 2,000 students take up that option to delay their fee payments, and an individual payment plan will be negotiated with them in the coming months about how it will look like in 2021 for them. But during this period of COVID and this second semester, we know that there'll be money in students' pocket because they don't have to pay their tuition fees. It's really important.
Excellent. So just to be really clear there, we're offering more support to students, but let's just say we know that their tuition fees are a big cost. What should they prioritise, Ben? Should they be prioritising tuition fees or their living and accommodation costs?
Yeah, and the way we've structured the support for this semester, we're trying to really emphasise to students that their living costs are the most important. And it's most important for them to have housing and accommodation, hence the tenancy conversation today, and access to food. So the real stalwarts of our support for students are ensuring they have access to food and access to housing.
Absolutely. So tell me, if we're aware of a number of different schemes and things that can support international students to get cheaper accommodation. Can you tell us a little bit about the government support, the temporary crisis accommodation, and exactly how a student would find out about that if they were in need?
Yep, so the Study New South Wales and the New South Wales government has provided a scheme that allows up to between 8, 12 or 20 weeks of accommodation based on people's circumstances. And students are able to apply through the Study New South Wales website. And to be eligible for that application as a Macquarie University student, all you have to have done is applied for the Student Success Package. So if you've applied for the Student Success Package, we can provide you with a document to attach to your application through that scheme, and they'll make you eligible to apply for that crisis accommodation.
Excellent. So step 1, put in your student success support application. Step 2, apply for that crisis accommodation, and that will be evidence for you to support your claim.
Yeah, and we'll provide a letter to attach to that application as well.
Excellent. Now, what would happen if you're a domestic student, and that particular New South Wales government support was for international students? What should you do if you're a domestic student?
Yes, so for domestic students, our primary focus is negotiating better accommodation outcomes, much to the conversation Sean had with you about students approaching accommodation providers that are of a rent or of an amount of money that is affordable in the longer term. So our accommodation service on campus has a list of providers close to the campus, including the colleges, that are prepared to offer discounted rates going forward. And it's important for us to manage that through the accommodation service in terms of matching up your needs and those that are available nearby. It's really important to make sure you've got a house over your head, but we don't want people's debts to increase to the amount that it becomes unsustainable in the longer term.
Absolutely. And I can only stress to people there that approaching the team at Accommodation Services, either by emailing housing@mq.edu.au, giving them a call on 98507965, or even if it's out of hours, as we talked about before, Ben, there's an out of hours number. Do you want to remind us about that for students to get advice?
Yeah, so Macquarie University has a 1-800-CARE-MQ number. If you look for the exact digits, and it's on the back of your student card, and very easy to solve the exact digits, but 1-800-CARE-MQ. And on top of that, you can access the MQ Wellbeing app, which is free for all students and staff at the university. And the MQ Wellbeing app is available on Android and Apple stores. And through that app, you've got links to all the emergency service providers, including the 1-800 number.
Excellent. That's a great resource there for students as well. So tell me, Ben, what else is available under the Student Success Support Package? What are some of the other support initiatives? As you've said, we're focused on food and accommodation. What else is happening in that space?
Well, in terms of food, much like in session 1, we continue to provide emergency vouchers or e-vouchers to students so that they may access I guess, groceries online or in person. During COVID, we went to the e-voucher system to be COVID safe and ensure students have access to funds. And we're doing that in enhanced ways in terms of the delivery based on eligibility, but also delivering money at regular amounts to students as well, based on their assessed need.
That's a key, isn't it, Ben? That regular amounts coming through, and that we're, you know, hoping students have a realistic sense of their budget between now and the year. What advice are you providing to students about a budget, a weekly kind of budget? What should they be working to?
In general, we expect students to need at least $6,000 until the end of the year.
Between now and the end of the year. And that's to cover all accommodation and living costs?
Basically, it's to cover accommodation, and food costs are the most important ones that we think that people would cover, and also some medical costs as well. So the bulk of the primary cost that someone would have would take $6,000, and that's not to cover tuition fees. So just to reiterate, we don't expect you to pay tuition fees with that $6,000.
Okay, keep the money for food and accommodation there. Now tell me, Ben, we've just got a couple of minutes left, but some of our people on our students today will no doubt have put in one of their applications for the Student Success Support Package. Two things: when should they expect to hear or start if they need to have some of their fees returned to them? When should that start to flow to them is my first question.
Yep. So if students have reached out to Student Wellbeing who had already paid their fees and need money access to that money, they can contact Student Wellbeing, and we've already had funds flowing back to students who, at that amount, $6,000, just so that we know they're funded until the end of the year. That's the amount that we're sort of refunding if you paid fees, and that allows them to pay their fees for the extended period.
Okay, so that money's starting to flow. If students are concerned and they need to get back in touch with Student Wellbeing, maybe their circumstances have changed, or you know, something else has come up for them. What's the best way for them to get in touch with you and your team?
Well, there's multiple ways of going about it, but the easiest is calling 98507497 or emailing wellbeing@mq. We also have wellbeing advisor checks that someone can book through the Student Wellbeing page. So you can just click want to talk with a Student Wellbeing advisor, you click on that and we'll get in contact with you through a phone number, most likely.
Okay, that's good advice. And I think, as we always say, it's really good for students to reach out to us early. There's no silly questions. This is a really tricky area to navigate. It's very, very complex. And so the earlier students reach out, surely that's better, isn't it, Ben?
Yeah, with most wellbeing issues, the earlier you get to it, the earlier you get better. And in terms of financial sort of situations, much like leases, you don't want to go down a rabbit hole of having too much owed to other people, so you want to minimise the damage in that sort of situation and improve the path to getting better.
Absolutely. And can I just double check with you, students that are most in need, there's different levels of support, different options of support depending on people's needs, isn't there?
Yeah, student wellbeing assesses cases on a case-by-case basis based on the exact needs of the student. And we recognise people's circumstances have changed throughout COVID, and not just theirs, but their family members. Much like the rules about tenancy, about how people have been affected within a home, we take that into account when we review our applications and also the expressions of need.
Okay. Anything you want to add there at the end, Ben? Anything that I've forgotten to ask you that would be useful for students?
Yeah, I realise most of the people in this forum today were concerned about their own wellbeing, but please continue to be reaching out and looking out to their colleagues and their peers amongst the cohort and making sure that they're checking in, because we know it's a very tough time, and staying connected with those around us will help us through this.
Absolutely, and a great reminder as we wrap up with Community Week as well, that it is such an important reminder. So thanks, Ben. I've got a few final housekeeping and messages for students. Thanks a lot for your time today, Ben. We're going to get back in touch with everyone with those really helpful resources and key points and information that Sean shared with us. I will get them reliable. My notes are everywhere and scribbled down. It's just like I've been in a lecture today, but we will get that back out to you. If you haven't already done so, the two things that you must download is My Legal Mate app. You can find the link for that on the university's website, or you can use the URL students.mq.edu.au/mylegalmate, and of course the Wellbeing app that we've referred to. That's got everything there. If you do have questions and need help, reach out. Student wellbeing, if it's a general support issue and financial assistance. If it's specifically about accommodation, reach out to our accommodation services team, housing@mq.edu.au, or give them a call on 9850 7965. And remember, our out of care hours that can support is available via the app as well. So we are here to help. We are working through these issues in the support package, and we can definitely connect you if it is a complex situation and you need additional advice. We can actually refer you through and help you access that expertise at Redfern Legal Centre. So I hope everyone has a really good weekend. Thanks so much for your time this afternoon, and we'll be sending out the recording as well, so you can go back over today's webinar. But thanks for the great questions, and I hope you found this valuable, because I certainly have. Thank you and take care.
Thank you, Kylie.